defense. The first is a motion to dismiss the indictment, or in the alternative, motion to transfer jurisdiction to juvenile division, or alternatively to exclude all statements made by the defendant to law enforcement. Second motion is a motion to transfer jurisdiction to the juvenile division of the circuit court on grounds of Sixth Amendment violations related to jury determination factors. So at this point in time, how would the defense like to proceed?
Yes, Judge, I would begin with the defendant's motion to dismiss.
Okay.
Judge, for the record, just so the court's aware, I've indicated the same to Ms. Fowler today. I'm going to just be relying on the authority that it's cited in both motions for today. I don't have any additional authority or case law to present on either one of the motions. So to begin, Judge, defendant's motion to dismiss the indictment, or the alternative, motion to transfer jurisdiction, juvenile division, or alternatively exclude the statements made by the defendant to law enforcement. Judge, this motion was filed on April 20th of this year. I rely on the 5th, 6th, 8th, and 14th Amendments of the U.S. Constitution, Article 1, Sections 2, 9, 16, 17, 21, and 22 of the Florida Constitution. In addition, relying on Florida Statute 119.071. And we're asking for a dismissal of the indictment. I'm not conceding any grounds because of the other motion that's sort of before the court as well. I'm not conceding that this is properly a direct filed case, nor am I conceding that we should be here under indictment. But as I'm asking it for a motion to dismiss, I wanted to start with this motion. So, Judge, on August 6th of 2024, a notice of direct filing was filed by the state attorney's office, and a grand jury returned an indictment charging Ms. Egler with 2 counts of first-degree premeditated murder. Same day, the court issued not this court, I believe it was this court, that transferred the case to the criminal division. So that's what brings us here. Now, what happens in the case is that Ms. Egler makes a 911 call. Law enforcement arrives. Many of the officers have body cams. Some of that body cam footage got it to the media. In addition, Ms. Egler was taken to the Palm Bay Police Department inside of a room with 2 detectives. That room was recorded, so video recorded. So everything in that interrogation room was recorded. It was supplied, obviously, in discovery to the defense. But what I learned was that either state attorney's office or Palm Bay Police Department, as an officer of the court, I can tell you it was not me nor anyone in my office, gave the body cam footage and the interrogation to the media. And certain media outlets ran with the story. Page 2 of my motion, going into page 3, lists out and also has the web addresses, and this just goes back to the date of my motion, so April 20th. On clickorlando.com, they ran with body cam shows police questioning teen accused of killing mother's boyfriend. The story, as of April 20th, had been viewed on YouTube over 1,000 times, almost 2,000 times. Then Law&Crime Network, that also streams on Peacock, ran what's called On the Case with Chris Stewart, Season 1, Episode 36, titled Florida Teen Admits to Killing Mom. And the episode can also be found on Facebook, the entire episode. The Facebook stream as of April 20th had been viewed over 2,000 times. There's also a podcast that streams on Spotify with the same exact episode. Then Instagram, someone posts the interrogation that they obviously got from the media onto Instagram. That, as of April 20th, had been had over 5,000 likes with 764 comments. Then dailysignal.com ran teen girl allegedly confessed killing mother's boyfriend after misgendering dispute. And the other title of the same stream, another trans shooter, ? Teen girl allegedly shot family members. Then YouTube ran an additional link to the On the Case episode, which had over 6,000 likes and over 364,000 views. And Spreaker.com ran Florida man and Florida teen stages scene, murders mother, slaughters mom's boyfriend, Julia Egler. In addition, Facebook ran an interrogation, the video of the interrogation, posted by someone by the name of Scott Presler. It was liked over 2,000 times with over 700 comments and 300 shares. And again, this is of April 20th. Facebook ran another stream with the interrogation and body cam photos, viewed over 8,000 times with 28 comments. And YouTube ran another one. These are all separate streams. Have been viewed over 2 million times with over 46,000 likes and 10,600 comments. The party that uploaded this on the YouTube is EWU Bodycam, and that particular person has over 3 million subscribers. And YouTube again, there's another stream of the Bodycam and interrogation, viewed over 139,000 times with over 1,450 comments and over 9,000 likes, again, as of April 20th of 2026. And I know, I'm sure the government's going to say, well, they're direct filed. Respectfully, Judge, it shocks the conscience that a child is put on TV and then all over the media, all over social media, all over podcasts, and the public is told of something that's extremely private in their personal life, whether they're transgender or not, and I'm not here to argue that spectrum whatsoever, but it's something that's extremely private. And to get shock appeal, to get clicks, to get viewership, that shocks the conscience of this. And not only, but it also disrespects the two victims in this case, that their laundry, dirty laundry, is aired out to millions of people at this point. And I understand direct file, we treat people differently, direct filed or not. I don't care what you want to call it. She's a child. A child and her face put all over the internet. For what? Clicks. Popularity. That's what children do. That's not respectfully what our media should be doing. And I'm a huge proponent of the First Amendment. I believe in the First Amendment, but there should be, just like any other amendment, some checks, some balances. And Judge, we do have a check and balance in the state of Florida. Florida statute section 119.071 2E says, any information revealing the substance of a confession of a person arrested is exempt from 119.071, which is public records, and section 24A, article 1 of the state constitution, until such time as the criminal case is finally determined by adjudication, dismissal, or other final disposition. None of that had happened. There's been no adjudication, there's been no dismissal, there's been no disposition at this time. If you look further in 119.071, there are exemptions that for public records disclosure. This is not one of them. In fact, again, 2E's specific. A confession cannot is not public record. And there are remedies within Chapter 119 for violations, except they provide for civil actions, injunction relief, and attorney's fees. No amount of civil action, injunctive relief, or attorney's fees is going to rectify the constitutional violations that Ms. Egler finds herself in today. There is no chance, assuming prospective jurors walk into this courtroom and are honest, that we're going to be able to sit a jury within any amount of reasonable time, unless you're talking about weeks and months as reasonable time. What this has done, what this violation done by the state attorney's office or the Palm Bay Police Department, and the Palm Bay Police Department is an agent of the state, is going to cost this county lots of money, because if there has to be a change of venue, then we need to go to another jurisdiction to try to obtain a fair jury that doesn't know anything about this case, that hasn't formed their opinions. And the web addresses are on the motion. The comments, some judge, are outright disgusting. Disgusting. What they want to see happen to a child, regardless guilty or not, what they want to see happen to a child that quote unquote confesses. Bring back the death penalty for her. More than one comment saying that. So that shows what this public is now thinking and believing in. And I make the promise today that these comments will be talked about during jury selection, because I need to make sure what jurors we have in our pool when that day comes for trial. The only remedy that makes sense, Judge, is a dismissal, and I know dismissal is always not what courts want to do, nor what some of our higher courts say they should be doing. It's too big of a penalty. That's why I've asked that the court transfer the case back down to the juvenile division. There has to be a remedy. Has to be. The injunctive relief, Judge, the damage has been done. The court can order no more posts or stories about the statement given by Ms. Egler to either Detective Cedric or Detective Brown in the interrogation room, or to the law enforcement officers on scene during a body cam. That's not going to fix it. It's not going to rectify what has already happened. Attorney's fees, Judge, you know who I work for, so I don't have any attorney's fees. And civil actions, I'm not here standing as some civil attorney looking to sue. I'm a public defender. So I can't imagine any other way to rectify what has happened than to actually put some teeth in 119 statute and ensure that this doesn't happen to other people. Because let's also envision, say down the road, hypothetically, a jury finds her not guilty. Now what? Her life, her reputation has been ruined, not for a year, not for 2 years, the rest of her life. And she sits here as a 17-year-old. So what, another 60 years, 70 years? And these are posts that can never be taken down. I am prepared to play some of the posts if the court deems it necessary. But I have attached, like I said in my motion, the websites to it. And I will, with this caveat too, for whatever reason, I think because of the, when it was converted from Word to PDF for the filing, some of the hyperlinks don't work, but if you actually copy and paste it, it does work. And like I said, I'm prepared to play that today if need be. reason why I hesitate, Judge, is that I know the media is in here today, and the last thing I want is for them to be playing portions of this hearing with me playing portions of her statement to law enforcement. I really don't want to go down that path. Judge, there's no other way to say that the disclosure is inflammatory. It's extremely prejudicial. I have dealt with high profile cases, and the last of which it took us well over a month to pick a jury. And that wasn't because interrogations were, put before the public. Actually, in one case, Judge, we had where things were limited from the media. But, so, Judge, again, it is our request under especially the 6th and 8th and 14th Amendments of the U.S. Constitution, that the court dismiss the indictment entirely, or at least in the alternative, transfer it back to the juvenile division. I anticipate the state's going to rely on a couple of cases on this issue, Judge, and I'll wait, in all fairness, to Ms. Fowler in her argument, but just do request a brief rebuttal after Ms. Fowler has made her argument and presented her authority.
All right, Ms. Fowler.
Yes, Judge. So it appears there's no real dispute at this point that the items that were released after discovery was provided to the defense. And in that case, everything is deemed public at that point. There are exemptions, and those exemptions can be confidential exemptions, or they can be exemptions. And there is a difference between the two. Exemptions, we can limit the disclosure, and confidential exemptions, we must prevent the disclosure. And we're not talking about any confidential disclosures in this case. As everyone is aware, this defendant has been transferred to adult court. Once you're in adult court, you are treated as an adult. At that point, it does not matter your age, but for limited circumstances as far as death penalty, life sentences, those types of things. But all other aspects of being treated as an adult are in effect at this point for this defendant. There was no motion to seal any records or to prevent the disclosure. Once the defense received all of the discovery, there was no motion made to prohibit or asking the court to limit the disclosure of these materials. The materials that have been disclosed, there's been no specific showing that anything that is construed as a confession. And the sum total of an interrogation is not a confession. Only those limited portions where someone is actually admitting to committing those crimes are considered to be the confession portion. So as long as those specific items are redacted for purposes of release, the rest is required to be released. So very limited exposure. There's been no showing that when Palm Bay Police Department released the interrogation that was done post Miranda by detectives Nicole Brown, and Ken Shedrick, that it wasn't redacted properly. There's been no allegation that they didn't redact it properly. At this point, it appears that the only thing at issue are the clickbait, basically, is what it is. Media was provided, as we are required under the Florida and the Sunshine, and whatever those media outlets assigned it to a title to entice people to click on it, obviously the state is in no way responsible for that. The information that was provided is something that we have an obligation. The cases that I sent to the court earlier, everything's open in the sunshine, and everything is supposed to be released unless there are those specific times when it is not. And here the only thing even remotely at issue is the exemption as far as confessions. And again, Palm Bay PD, when they're the ones that released that interrogation, they're the ones that redacted the actual confession portion, and there's been no showing that they did not do it correctly. obviously any case that has media, there is a component to that in jury selection where jurors are questioned about any pretrial knowledge that they have prior to coming in. That is an issue in all cases, and it is addressed then. Sending it back to juvenile court, dismissing it, none of those are appropriate remedies under the statute. And again, any pretrial publicity issues can be addressed during jury selection.
All right, I did have an opportunity to review the state's case law that was provided. So, Mr. Perolo, you stated that you wanted to rebut some of the points made by that particular line of case law.
Yes, Judge, just briefly, I mean, I believe the cases that I reviewed, some obviously have to do with the motion that we haven't argued yet. There's a trial motion memorandum and affidavit from the Nicholas Cruz case. I'm not going to comment on that. It's not authority. It's a motion. And then the Times Publishing Company versus State was the other motion or case that I believe the state's going to be relying on for this particular motion. And Judge, in that case, there's talk of the court order. There's a court order that already sealed certain records, and they make obviously highlighting that there is an importance to taking out certain portions. Again, in our sunshine laws, there is an exception. And the exception is the substance of a confession. And it doesn't, the confession can be statements that are made in totality that signify an admission of guilt. And the portion, and again, I'm sort of stuck, and I'm willing to supplement after today to make it part of the record, but I'm not going to be in this position where I'm playing stuff on the record with the media here that potentially then they broadcast it yet again.
Let me ask you, I don't mean to interrupt you, but are you arguing that the manner in which Palm Bay PD redacted the audio was not sufficient or inappropriate?
Correct.
And
So.
that is where a review of the actual
Right.
audio would be needed?
Yes, Judge. And again, when you look at the streams, the reports, on the case with Chris Stewart, the title itself, Florida Teen Admits to Killing Mom. They got that from the portions of the interrogation that were given to them by Palm Bay Police Department, or whoever, on the case got it from somewhere.
Well, but you're not arguing that Palm Bay PD had any part in the titling of the links, articles, whatever the case may be. I mean, that is something that was done by an independent third party based on the video they received.
Right, but there's enough information that Palm Bay released that gives, pretty reputable, let's forget about the other sort of streams and podcasters, but pretty reputable people like Chris Stewart on the case, a show on Law&Crime, that smart enough to connect the dots in what Palm Bay gives them to say Florida teen admits to killing mom. An admission, that's a confession. So that arises from the parts of the interrogation that Palm Bay did provide to the media.
So basically the titling of whether it's an article, a link, a podcast, essentially is based off of the opinion of the outlet, would it not be?
It's a little bit more than that. I would agree, but when there are parts of the interrogation that are played, that are disseminated from the police department to the media, there is virtually no other logical, conclusion to come to, and it's an admission. Wasn't me. I wasn't there. I don't know who did it. And again, like I said, I'm prepared to play him, but I sort of feel like I'm stuck between a rock and a hard place. And the best I can do is just supplement after today with what is actually cited in my motion. I could put them on a flash drive, but there are parts of the interrogation where even Detective Brown and Shedrick sort of, walk her through, try to summarize some things that, again, any logical, rational person watching it is going to come away with, oh, she admitted to it. Because she's not up there, I don't know what you're doing. You're arresting an innocent person right now. I don't know anything about it. There is no logical person to come away saying it is not an admission.
Okay, so just so I'm clear on what your argument is, you have an issue with the way that these things were characterized or titled by various media outlets, but let's take away that component. Your position is still that the video and audio itself was insufficiently redacted because you can, just based on viewing the video and listening to it, it amounts to a confession.
Right. And there is no other reason to publish that but for the fact that it's a child admitting to a pretty heinous act. Put it that way. There's no reason to do it. There's no, media, by media, I'm talking about the real media, true media, not some independent podcaster out there. But the media puts a story forward based on some fact, and their headlines usually reflect a logical conclusion. That's the logical conclusion made, especially by Chris Stewart when Florida teen admits to killing mom.
So if it is the norm that discovery materials, once disclosed, are in the sunshine, wouldn't it be the case that any type of video that shows a police interview or interrogation would fall under your argument if the person is not actively defending themselves against the claim?
It depends. It's going to be case by case. It's going to be depending what that person is saying. I mean, it's hard to really answer the question other than it depends. But our laws carve out an exception, a specific exemption to the sunshine laws, and that's the substance of a confession.
I think because the way the motion was laid out, it provides the links, but of course I don't review these things when they involve cases like this. I don't feel like it'd be appropriate for me to do so outside of the courtroom. So when I view things as when they're presented to me in the courtroom. So as I'm sitting here having reviewed the motion, I see the links, but there's no outline or summary of what portion of these publications, or more specifically and more, to the point, which portions of the video you believe were inappropriately disclosed.
Well, Judge, I would ask then to be able to submit, either a memo of some kind to give in the court quotes from it, exact times from it. I can even have my IT person put them together on a flash drive as well and include that as part of the record. Again, I'm not going to be in the position of publicly in this public courtroom airing out things like that when they could be played on the 5 o'clock news. So I refuse to do that.
Okay. All right. Did you have any other portion of the case law that you wanted to discuss?
Not for this motion, no, Judge. Thank
Okay.
you.
And Ms. Fowler, just based on any new arguments or points made by Mr. Proler, was there anything else you wanted to put on the record for the purpose of the first motion?
No, Your Honor, I'd still rely on the cases I previously provided.
Okay. All right. Well, obviously, in order to, in one of the cases that I reviewed, it basically goes through the exemption of the confession component of a video and states that, yes, that, is something that should be redacted. Beyond that, I don't know if it was properly done in this case. Okay? I mean, we've already kind of flushed through that. So I think it's going to be necessary for there to be some sort of supplementation of the motion so it's properly before me and I can view the relevant parts of the video the proper way. I'm not going, again, I don't feel that it would be I don't feel that it's best practice for me to just jump on social media and start watching through whatever is posted there. It needs to be something that's presented to me through the courtroom. So I'm going to request that that occur so that I can view the video the proper way, and then I can make a proper ruling on the issue.